Good afternoon, Gihan.
And thank you so much for coming, all the Kabari magazine. It's my pleasure.
Thank you. Lately, you had the decision made by the Ninth Circuit. Could you elaborate more?
Okay, this is a great decision that came down on July 25th, 2015. And basically what the decision comes, or the proposition it stands for, is as follows. If a parent can establish that a harm has occurred to his own child on account of the parent either Chinese ethnicity or Christianity, that parent is entitled to protection, even though that parent has suffered zero or suffered nothing. As we know, in all asylum cases, every person must show that he personally has suffered harm in order to get protection from the United States government. We have never had any case prior to that has held that a parent on behalf of his own child is eligible for protection solely based on a harm that occurred to a child. So even the question that was raised and even was framed by the judge that wrote the opinion, can a parent seek an asylum based on a harm to his own child? Initially, the immigration judge in San Diego has denied the case, and he said our asylums law have consistently held in order to seek protection, you need to show that the harm has happened to you, not a harm that has happened to an own relative or a family member. The Ninth Circuit has found that this to be an atrocious or misapplication of the law, because they said a parent can suffer a tremendous harm by a loss of a child or by harm to a child. Okay? And if you ask me more about the case, I'd be more than happy to provide
Maybe
more
can you
information.
elaborate what a harm to a child means?
Okay.
Examples.
Let's say the example that happened to my current case, and how could it be utilized later on other different cases. The first one is, in my particular case, the client child was not provided proper medical attention at the hospital in Indonesia, because the doctors was a Muslim doctor, and the parents were both Chinese and Christian, and they neglected the child, and as a result of that neglect, the child died. She was still 3 months. So the judge said, well, that was a child, that nothing happened to you, it's gone, you're not eligible for protection. On an argument to the Ninth Circuit, we found that even if you personally suffer a physical harm yourself to qualify for asylum, your physical harm can heal, but your loss of your own child will remain with you forever until you put your head to the grave. So it's a tremendous harm. So this is where the Ninth Circuit has found. But how can this case be applied to other cases? For example, I mean, it was atrocious in my own case where the child died, but that doesn't mean that the child or another parent or an asylum seeker cannot get protection. So, for example, let's say other cases. If we say that the child in the school has been mocked through because he's Chinese, he was called names, he had suffered problems on account of his ethnicity or religion at school, and he suffered a psychological trauma. And that psychological trauma for a child has caused him to see a psychiatrist. Let's put even a minor harm, okay? That parent from Indonesia can get me all these documentation of the attacks on the child, the psychological trauma, or even attack on their own little child, and present it, and those parents themselves can seek protection and not just seek and receive protection based on harm to that child. So this is the application of the case towards every immigrant community that follows the Ninth Circuit jurisdiction.
So the burden of proof is whether the person has been targeted in Indonesia.
Well, we have to show that the child has been targeted, and the target has to be because of a protected ground. I believe in the Indonesian community, the protected ground namely would be either the Chinese ethnicity or the Christian faith.
Okay, all right.
Okay.
So Are there a lot of cases like that here at this moment?
Right now, we're applying these cases to other application through different other communities, not specifically Indonesia, but you could utilize it because it's not just limited to Indonesia. It's limited to every immigrant community that follows the Ninth Circuit jurisdiction. And if you ask me who are the states that follow the Ninth Circuit jurisdiction, I would tell you California. We have Nevada, we have Arizona, we have Hawaii, we have Washington State. That comes to the best of my knowledge.
Okay.
Oh, sorry, Portland, Oregon.
Portland, Oregon.
Yes.
Okay. And if a child is very sick here in the U.S. and they applied for asylum, is there any
Sick?
case?
No.
No.
The question is, in order to receive protection based on the case, is not because the child is sick in the United States. You have to show that your child has been harmed in your home country, and he was persecuted because of his race or religion. The parent himself can come in and seek protection based on that child.
Okay. In order to have this case approved, what documentation do we need?
Of course, the parent has to present the birth certificate of the child. We also have to present if that child has been beaten. Let's say the child has been tortured, beaten in his school. We have to show medical records from the doctor. Possibly if the child was treated in Indonesia, a psychological treatment for a trauma. If you received any prescription as a result of the medical treatment, prescription records. Any memos coming back and forth between the parent and the principal of the school requesting protection, any police report that has been filed and has been neglected. So different items to show the harm that has happened to the child through a chronological record.
Obviously, the parents has to be here to apply for the asylum.
Of course.
Right. It cannot be...
No, because asylum, you have to have come at the border of the United States or you have entered the United States territory.
I see, okay. All right.
And we don't have refugee processing for any part of the world except Iraq for some reason. Only the United Nations is helping Iraqi in Jordan.
And the name of the case that you handled?
Suma Long v. Holder. It was published on July 25th, 2013. So this is a winning to the immigrant community. I think so.
Okay, very good.
Thank you.
Okay, thank you very much
Thank
for
you.
having the time to interview.
Yeah, thank you.
Yeah, thank you.